Dear colleagues, dear guests, welcome to tonight's SIAC-CIArb debate. My name is Qian Wu. It is my great pleasure to be your host this evening. On behalf of the Singapore International Arbitration Center and the Singapore branch of the Chartered Institute of Arbitrators, it is our great pleasure to have your company tonight. Before we start the debate, please allow me to address a few minor but non-negligible housekeeping matters. First, as a courtesy to our debaters, could you please turn off your cell phones as well as your electronic devices during the whole debate? And for those claiming for CBT points, please also remember to sign in now. And don't forget to sign out at the end of the debate. In addition, your feedbacks are very valuable to us, so could you please fill in the feedback form on your seat and please deliver it to us at the end of the debate. Thank you very much. Without further ado, I would like to introduce Mr. Garen Ball, the president of the SIC Court of Arbitration, to deliver his opening remarks. Thank you.
Thank you so much. The most important thing about opening remarks, as we all know, is that they be very, very short, and mine will be short. They are mostly to say thank you. Thank you to the program sponsors. Thank you to my fellow judges, Ariel Yee and Lucy Reed. Thank you to our participants, and in particular, Francis Xavier, who will do proper introductions. We have, in many ways, the best of the world here. It's suiting for SIAC, of course, as a global arbitration institution, to have the best of the world, not just common law, but also civil law to debate before you today. Thank you, perhaps, though, most importantly, to the SIAC Secretariat, the Registrar, the CEO, who have organized this evening's event. The fact that 400 or so of you came to listen tonight, I think, is testimony to the rise of SIAC and to the importance of it in this legal community. And thank you, all 400 of you, for coming tonight. I know you have many things to do, but the fact that you came to an SIAC event like this means a lot to all of us and to SIAC itself. Thank you.
Thank you, Mr. Bond. Now I would like to invite Mr. Chu Shouyun, the chairman of the Chartered Institute of Arbitrators, to deliver his opening remarks. Mr. Chu, please.
Ladies and gentlemen, very good evening. On behalf of the Singapore branch, the Board of Directors, a very warm welcome to the second edition of the SIAC-CIArb debate. We hope that it will be an annual event and that the turnout in the subsequent editions will be as impressive as it is this evening. We, in fact, had to stop taking registrations some weeks ago. It was a complete sold-out, no doubt because of the one public CBD bond that's on offer, and the fact that it's a free event, both very important considerations in Singapore. So thank you once again. But I think the real reason why all of you are here is really because of the stellar cast of debaters that we've managed to persuade to join us this evening. No doubt the debate will be exciting, and it's certainly, I think, hotly anticipated, I hope. So thanks again. Francis will effect the proper introductions in due course and also introduce to you the very few rules that we have for the debate this evening. But it also remains for me to thank again our sponsors. And that's the real reason why it's on a no-fee basis. Thank you once again to our good friends from Fountain Court Chambers, and FTI Consulting for extending your kind sponsorship for this evening. If I may, just very quickly, a quick plug for the Chartered Institute. Some of you here are already members. Those of you who are not, may I encourage you to consider joining as members. We are an international organization. We've just crossed our 15,000 membership mark. And in fact, quite interestingly, the 15,000 member is a Singaporean. So we hope that those of you who have not joined up as members, please consider doing so. There are membership forms and materials just outside at the hall. I wish everyone an exciting evening ahead. Thank you.
Thank you, Mr. Chu. Now we would like to start the SIAC-CIArb debate. The subject of the debate has been raised, addressed, challenged, and revived in Miami, in London, in Singapore. And tonight, we have the privilege to hear a live debate on this motion. That is, this House believes the practice of party-appointed arbitrators is a moral hazard in international arbitration and should be abolished. I will now hand over the time to our moderator, Mr. Francis Xavier SC, to introduce the debaters, the judges, as well as the format of the debate. Thank you.
Thank you. Thank you. Now, I think first of all, we want to thank the judges, Gary Bond, President Court of SIAC Court of Arbitration, Ms. Ariel Lee, Member, SIAC Court of Arbitration, and Lucy Reed, Director, Center for International Law. We're very grateful that they're here. Now, there's already tension on my right and left. The gentlemen on my right have already lodged a complaint saying that they've been approached before the debate by two members of the judging panel who have indicated to them that they are against the motion. So I understand that Mr. Landau is in the midst of preparing his application to
remove them.
To remove the judges. Now, I think we're going to start. The rules are very simple. No fist fights.
No fist fights. Oh, no, dear. No, we didn't. That wasn't agreed. Yeah. No.
Yeah, now you know.
It's free fights, isn't it?
So 12 minutes each speaker, right? So first speaker for the motion, first speaker for the opposition, and so on. After which, you, the audience, get 20 minutes to air your grievances and to debate with the debaters, all right? At the end of which, each team will be given 5 minutes, one representative 5 minutes, to respond to what you've said, to your grievances, if they choose to. And at the end of all that, when the dust is settled, we will have a vote by a show of hands from you as to who you think carried the motion today, all right? After which, the judges will, it's an odd sequence, I know. After which, finally, the last say will be with the panel of judges if they haven't been removed by then. And one of their mates, having taken into account your vote, will express their views on what they've seen or heard today. Without further ado, I'm not going to introduce, I'll introduce the speakers as I call them. First of all, the first speaker for the motion, Mr. Darius Kambata QC, who was, as you would be aware, Additional Solicitor General of India for 3 years, after which he was Advocate General for the state of Maharashtra between the years 2012 and 2014. Without further ado, I call upon the first speaker of the proposition to address you.
Thank you, Francis. Mr. Chairman, judges, two of whom we've now been told are doctrinally predisposed this evening, my fellow debaters, ladies and gentlemen. An arbitrator traditionally has been a judge whom you could choose for yourself. That's what they all said in the old days, at the turn of the 20th century. But times have changed. We are now in an era of rapid globalization, where all of us, I believe, want to transform arbitration into an autonomous and independent legal order. My friend Emmanuel himself has written a beautiful book, Pathbreaking, where he says an award is a decision of international justice and an arbitrator is an international judge. Now, as we move towards this new transnational legal order, the question before you today is whether we stay entrenched in the so-called fundamental and historic right of parties to appoint arbitrators, or must we now welcome change and go forward into a brave new world where an arbitrator is, in all respects, an international judge. This is inexorable, and I think it must come sooner rather than later. Now, let me run through very quickly the usual arguments in favor of party appointments, and I'm sure my friends here will have some new ones up their sleeve, but the big five, as it were, are these. Confidence in the process. Parties and lawyers like to appoint or choose their own judges. Who wouldn't? Gary Bourne, in his book, refers to the Queen Mary College survey, where he said 92% of practitioners preferred some role in selection of the wing arbitrators. But that same survey said 27% preferred a role in selection of the chairman. That's very significant because that showed the subconscious recognition that a chairman has to be truly neutral. 2, inertia. Fundamental right, historic practice. It's like saying today, we will not have self-driven cars in the future because we've always driven ourselves. 3, the shared outlook argument. Wonderfully enunciated by Duac Bishop and Lucy Reed in their article. A cultural legal affinity, a broad doctrinal sympathy, that's what parties look for when they appoint. And as Martin Hunter famously said, when I appoint an arbitrator for a client, I look for someone with a maximum predisposition towards my client's case, but with the minimum appearance of bias. 4, a subject matter expertise, horses for courses. You need certain special skills, which to my mind is really just a euphemism for the shared outlook argument. And 5, the big elephant in the room, party autonomy. I think that's been a bit overplayed, and my friend Toby is going to deal with that in greater detail. But the classic definition, I feel, of party autonomy is in Bharwati's case, where the US 7th Circuit Court of Appeal said party autonomy is so absolute that it is a freedom to stipulate dispute resolution in any way short of authorizing a trial by battle or by ordeal, or more doubtfully, by a panel of 3 monkeys. No offense meant, all present persons excluded. Now, that brings me really to the shared outlook point, because I think that's the real point, the heart of the debate. Gary Bourne famously described an arbitrator, or quoted a commentator as describing an arbitrator as a chameleon who takes on the expectations of the party appointing him. Now, this is not bias. It has never been held to be bias, and it does not disqualify an arbitrator. But to my mind, that's what makes it all the more dangerous. I again quote Gary Bourne, who cited a Talmudic observation, and I think it's very telling. A judge who is chosen will search for arguments in favor of the party who chose him. So is partiality to a cause or a doctrinal predisposition something that is consistent with the role of an arbitrator today as an international judge? We are today in a world where we speak quite readily of an enforcing court enforcing an award which has even been set aside in its seat, of tribunals continuing with an arbitration though the court of the seat has injuncted them from doing so. This is now a new order on its own, and those who take part and who are stakeholders in this order must stand up and live up to the standards of being international judges. In the US, the old law was that the wing arbitrator or the party nominated arbitrator was presumed to be partisan, and you did not adopt the same standards to judge his neutrality or independence. That has now changed even in the US. It was never so internationally. Internationally, the same standard of impartiality and independence applied. And indeed, that must be more so in the new order. Now, there is a fine line, to my mind, between a culturally or doctrinally sensitive arbitrator and a committed or partial one. And that line becomes finer and more difficult to draw given the nature of arbitration or decision making. You have 3 men or women sitting there, often confabulating in the absence of the parties on their own. And you never know exactly how far the sensitive or the party-appointed arbitrator has gone. So, bringing all this together, what risks that we run? The moral hazard of having party-appointed arbitrators. The first, and I think I agree that that's completely exceptional, is of an arbitrator completely identified with the appointing party and committed to upholding its case. That's very rare. I concede that. But the more likely risk is having what Jan Paulsen calls the advocate arbitrator, who sees his role as espousing the case of the party appointing him and to even argue its case, if necessary, with the rest of the tribunal and sometimes even with opposing counsel. Charles Bra referred to that practice of shared outlook as benign, but I do not share his lack of concern. Third, a party runs the risk of appointing someone completely unknown to the rest of the tribunal, an unfamiliar face and force, and who would therefore ease himself into a dissenting role rather than be an equal member of an independent tribunal. For, in some cases, the repeat business danger that an arbitrator wants to be appointed again and will therefore depart from norms of proper conduct. 5, sometimes the risk of compromising the integrity of the tribunal. We had the Slovenia-Croatia arbitration where you had lawyers and arbitrators from the same chambers, something that is intelligible and acceptable in common law countries, but is extraordinary in civil law jurisdictions. 6, the ability of a party-appointed arbitrator to delay or to derail an arbitration, sometimes even by resigning to allow repeated appointments to his party nominating him. And as I said, the veil of secrecy shadowing the confabulations of the arbitrators makes it very difficult to draw the line between sensitivity, culturally compatible arbitrators, and biased ones. We're going to lose, and we have already lost, the benefit of quick sole arbitrations, because no party who has a right to appoint is ever going to agree with the other side on whom to appoint. We're also going to lose the benefit of an independent, neutral institution using its expertise in selecting the right arbitrator from amongst the vast numbers available today, and to make sure that you've got the right woman for the job in an era of increasing specialization and skills. You can't expect a party, or indeed a party's lawyer, to have all the knowledge a good institution will have. And then, of course, that brings me to the Vandenberg conundrum, where he said that in 34 out of 150 investment arbitration awards, there was a dissent, but each and every time that dissent was by a party-nominated arbitrator, the party being the losing party. There's nothing wrong in a dissent. I think a dissent is a good thing. But the 100% score of the arbitrator nominated by the losing party dissenting is troubling. Is it merely a case of shared outlook, or is it a coincidence, or is there something more, is what I put to this House. We are now aware that arbitration has ceased to be a purely contractual matter. There are public law elements, certainly. And certainly when we go with an award to various countries in the world, seeking their sanction, their sovereignty to enforce awards, we are invoking public law elements. We then, as stakeholders in the world of arbitration, have to stand up to that standard. We have to make international judges. And the time has come, however difficult that may be, to step forward and now say, let an institution appoint arbitrators, let there be neutrality in appointment, so that we have a tribunal where both the parties have mutual confidence in each and every one of the arbitrators, so that it doesn't become a battle for the mind and heart of the chairman, one wing versus the other wing, equal stature, unequal stature, trying to persuade the chairman, who then ends up being the only neutral, truly independent arbitrator. This is a brave new world, and I agree it is a step forward, but it is a step we must now take. It's a step that Chief Justice Sundaresh Menon not long ago spoke about here in Singapore, saying we must move away from our outdated notions and move forward into what the modern trends and pressures require today. After all, the arbitral process cannot rise above the quality of the arbitrators, which is what Arthur von Mehren had said. And unless we now move to the stage of neutrality of appointment, we cannot get away from the old notion of two committed or shared outlook wings and only one true neutral arbitrator. Let us leave aside words like fundamental or historic, or it's always been a contractual right, or party autonomy, as if that is something that overrides everything else. Let us instead have arbitrators who may have intellectual or doctrinal predispositions, but they are not chosen for that reason by any particular party in any particular case. I therefore commend stepping forward into this brave new world by this august House. Thank you very much.
Thank you, Darius. A forceful case of inclinations and predispositions. Whilst I note that the proposition seem to have abandoned their discharge application, I now call upon Judith Gill.
We haven't.
I hear a voice on my right saying they haven't.
Opposition is reserved.
Miss Judith Gill, the current president of the LCIA. Judith, over to you.
Ladies and gentlemen, good evening to you. The issue at the heart of this motion presents an interesting and important topic for discussion in arbitration circles. The role of party-appointed arbitrators is of course relevant to an assessment of how arbitration operates and how it can continue to improve and develop. But the propositions in this motion are flawed. What is contemplated is an extreme and excessive response to perceived issues, the scope of which have not been fully explored and are instead largely based on anecdotal evidence plus the occasional horror story. In short, it is a sledgehammer to crack a nut. The motion rests on two propositions. First, that the practice of party-appointed arbitrators is a moral hazard, and secondly, that as a result, the practice should be abolished. Well, let's look at the first, the moral hazard. The origins of that term were essentially a term of art used in insurance and economic circles. But let's assume, for these purposes, we all know what we're talking about here is shorthand for a risk of unethical behaviour. But exactly what behaviour are we talking about, and by whom? Is it the party who appoints an arbitrator because they seem, in that party's eyes, to be well suited to the role, and perhaps are even perceived to be likely to view the dispute in a way that would be favourable to the appointing party? Do we really think that that calls into question the ethics or morality of the approach? And what about the arbitrator? Is it unethical or immoral for that individual to want to ensure that a party's arguments and approach are properly understood and considered by the tribunal, particularly in circumstances where, perhaps for reasons of shared legal cultural background or social cultural background, that arbitrator may have particular and greater insight into the rationale, the so-called cultural interpreter role? I suggest to you that none of these are objectionable because they are entirely consistent with that arbitrator's continuing duty to act fairly and impartially. And that is the relevant benchmark. Now, some of you may be saying to yourselves, yes, but that's not really what's at the heart of the concern behind this motion. It's important to understand, therefore, exactly what we mean by moral hazard. I heard Darius saying on a number of occasions, no, we're not really talking about bias. We're talking about an arbitrator acting as an advocate, or we're talking about partiality to a cause. Well, frankly, I think we should be blunt. What we are dealing with here, when we describe the moral hazard of party-appointed arbitrators, is a risk of bias, a risk of partisan decision-making or behaviour by the party-appointed arbitrator, the risk of them favouring the party appointing them. rather than acting independently and impartially. And it's right to examine that, but I suggest to you the danger is in overstating both the risk of parties seeking such an arbitrator and indeed the risk that arbitrators will see fit to succumb to such conduct. So what's the evidence of bias? Well, I think it's agreed the evidence of actual bias by arbitrators in terms of verifiable and documented instances are extremely rare. They do happen. One does have the well-known examples of the Lowen type situation where an arbitrator subsequently admits that inappropriate pressure was exerted upon him by his government's authorities, or perhaps, as Darius mentioned, the recent case of the Slovenian arbitrator caught on tape disclosing the tribunal's deliberations to a party representative. But such instances represent a minuscule proportion of the many arbitrations conducted over the decades. And they also bear the notable feature of these being politically charged arbitrations involving state parties. In the context of the many commercial arbitrations, such instances of indisputable bias are much harder to come by. So instead, those who argue that we should all be very worried about this rely essentially on anecdotal evidence and dissenting opinions. Well, anecdotal evidence obviously should not be ignored, and one can't escape the fact that in certain jurisdictions this is more of a challenge. But ultimately, anecdotal evidence is neither a reliable nor a safe basis for the assessment of the true nature of the extent of any problem. Which leaves us with dissenting opinions and the uncomfortable fact, as mentioned, that, as commentators have highlighted, such a large proportion of dissenting opinions are written by arbitrators appointed by the losing party. But what should we conclude from that? Is it that the risk of bias is substantial and there's a major problem? Does it suggest that actually the system is not working? I think not. To state the obvious, in the particular case of a dissenting arbitrator, any attempt at partisan decision-making has failed. They were appointed by the arbitration party who has lost. As a partisan arbitrator on a three-person tribunal, you have to overcome the other two impartial arbitrators, or at least the impartial chair, in order for the ultimate decision to be effected. So the fact of dissenting opinions and what they represent should not be overstated. It's sometimes said that dissenting opinions undermine the arbitral award, but where majority awards and decisions by the chair are part of the agreed process, that is part and parcel of what the parties signed up for. And a dissenting opinion does not prevent an award being enforced. And if we can rely on the majority, or at least the impartial chair, not to be swayed by an unmeritorious biased dissent, surely we can have similar confidence in the many courts around the world who, thanks to the New York Convention, might be asked to uphold the award. And we mustn't equate dissenting opinions with biased arbitrators. Independent and impartial arbitrators can honestly and genuinely take different views on the evidence or the law. Judges in appellate courts do so on a regular basis. And not all dissenting opinions necessarily represent a completely opposite view from the majority. They may simply be relating to particular issues rather than the central reasoning or indeed the outcome. So we should not treat dissenting opinions as a proxy for bias. Objection is also taken to the unscrupulous arbitrators effectively manipulating the process of deliberation. The concern is said to be that they might extract concessions from the other tribunal members, particularly as the price of securing a unanimous award. And this, it's said, is even more pernicious than the dissenting arbitrator because it undermines the coherence and the sincerity of the award by pressing for compromises. But I have at least two issues with this. The first is that there is nothing wrong with compromise per se if it leads to a unanimous decision. When the parties select a tribunal, they don't expect three clones What they want is a binding result, and a degree of compromise arguably enhances rather than undermines that. Secondly, implicit in this concern is that the arbitrator seeking compromise is doing so on an unprincipled or somehow improper basis. But where is the evidence of that? And I think one has to view it with caution. How can we be sure that that's not simply the perspective of an arbitrator who naturally prefers his or her own intellectual reasoning and is perhaps frustrated at that being challenged? In short, the actual evidence of moral hazard, if we find that phrase more palatable than bias, is at best sparse. The risk then of bias also has to be weighed against how material it is and how one can manage it. It's not the occasion to delve into detail into all the different checks and balances, but they do exist within the arbitration process. And indeed, to me, there's an irony in our questioning before this House now that party-appointed arbitrators are a cause of a problem. Because enormous strides have been made to tackle the previous concerns that have been raised about such matters. It's now an almost universally accepted norm that arbitrators have to be independent and impartial. And that has never been so deeply entrenched in national laws, in institutional rules, and in soft law materials like the IBA guidelines on conflicts. Arbitration has its own safeguards: majority decisions or chairman's decision, the very real risk of an arbitrator being marginalised if they appear impartial, institutional controls requiring written disclosures by arbitrators of previous contacts with the parties, the institution's right to refuse an appointment of an unsuitable candidate, and the pool of professional arbitrators. We hear it said that, well, they'll be terribly concerned about repeat appointments. Well, A, they will be revealed by the disclosures now required, and secondly, that pool are going to be far more concerned with their personal reputations rather than the off chance of a particular party giving them repeat appointments. Plus, of course, we have the procedures for challenge and removal. I wouldn't want to suggest there's room for complacency. There isn't. We need to continue with this work in progress. We've got the recent arbitrator databases as perhaps the most recent innovation. This is all moving, but it's dynamic, and the concerns are being addressed. But we need to keep it in perspective and not deal with the alleged concerns by prescribing a remedy that could have drastic implications. So, to my mind, the moral hazard is largely unproven. There are checks against it. But let's turn to the second proposition. Is the risk of bias such that the practice of appointed arbitrators should be abolished? Well, I'm not going to talk about historical context, although this right has been around for a very long time. And I won't dwell overly on party autonomy, although it is indeed extremely important in many systems and to many parties that they do have the right to appoint. It's seen as a defining characteristic and key advantage, not least because it's a quid pro quo for effectively the right to appeal being taken away in respect of the arbitration award. But at the more practical level, the parties want this. They exercise the right to appoint, even when there is an option to leave it to the institution, or indeed, as under the LCIA rules, the default is that the institution appoints. In the majority of cases, the parties reject that for their own appointment. There's been no rush to change in the 7 or so years since this suggestion came to the fore. None of the institutional rules have changed to reflect that. Only one institution in Romania, their arbitration court of the Romanian Chamber of Commerce, they changed their rules in 2012 to remove the party's right to appoint. It was a disaster. They had to change it back 2 years later because their caseload had greatly diminished.
Judith,
and there were concerns of corruption. I'm going to stop. My final point is, be careful what you ask for when you think about the alternatives. There are huge problems with the sense of, with the use of institutions as sole appointers of arbitrations. It would completely change the dynamic of the appointment process. Thank you.
Thank you. Thank you, Judith. Now, before we delve further into the case of the unscrupulous arbitrator, I do want to remind the audience, and I was reminded before the debate started by Richard Haler, that you are entitled to jeer or boo or support. And the timing of this announcement is not intended to put any difficulties in the way of the next speaker, but we just wanted to remind you, with 2 speakers remaining, that you're entitled to that, all right? With that, it gives me great pleasure now to introduce the next speaker for the proposition, Mr. Toby Landa, who requires no introduction.
Ladies and gentlemen, my fellow debaters, one remaining judge who is not subject to a pending removal application. Judith has painted an entirely rosy but entirely unrealistic picture of the world of international arbitration. And let's face it, we're all being polite. We know it. There are 2 key points to address, and a third if I have time. The first one is the real nature of party autonomy, which is the driving force here. Judith wanted to sidestep it because it's tricky for her to analyze it. We're going to analyze it. Secondly, what is the moral hazard actually? What is going on out there in practice? Number 1, party autonomy. This is the core argument. It is a demand, thank you, of party autonomy that leads us to the necessary conclusion that people must be able to select their own arbitrator. Now, if you pause and you step back and you subject party autonomy to a little bit of scrutiny, we didn't have much scrutiny in the last presentation. Here's some scrutiny. There is nothing in the nature of party autonomy that leads you necessarily to the conclusion you must choose your arbitrator. What you get from party autonomy is that you have freedom to shape the process, for sure. And of course, within that, you may want to have a central key involvement and role in the constitution of the tribunal. But there are many ways of achieving that without simply making a direct appointment. You can have the choice of an arbitral institution. You can have the choice of an appointing authority. Within that, you can have the choice of setting out parameters for the selection. You can guide an institution by contract, by agreement. You can guide an appointing authority. You can steer them towards issues of nationality, issues of legal background, issues of sympathy, of culture, expertise, personal qualities, restrictions. You can agree to a process with an appointing authority of active consultation in order to collectively arrive at the appointment of the 3 best people, or indeed the one person that you really want. All of that is still party autonomy. All of it involves choice. All of it involves active participation in the process. And you can thereby address the needs that people keep calling for, which is let's have somebody who we trust. Let's have someone who's expert. Let's have someone who has got a particular perspective which is common to us. Now, I can feel a bristling already, especially from 2 members of the judicial panel. Why are they bristling? Well, I'll tell you, if we're honest, why they are bristling. That is because this is not a process about choosing the most neutral, best, most expert arbitrators. That's not what we want when we are counsel. What do we want? We want to win. That's what we want. We're there to win. We're not there to achieve some high ideal that this is a very neutral, independent tribunal. We want to win. Now, to win means to try and weight the tribunal beforehand, to get a vote on board as quickly as you can, in the hope that that person might also secure another vote from the president or the chair. And that leads us to the reality. The reality of practice is that there's an awful lot of time and expense now spent on due diligence of candidates. Huge amounts of man hours are spent and women hours are spent on due diligence. Due diligence means you try and explore every possible personality trait of your candidate. What do they like? What do they not like? What have they decided previously? What personal foibles do they have? How much can we predict human nature to the extent that we know that they're going to like our argument? Are they broad construction people, or do they go for black letter details? Are they merits-based or not? Put this into investor-state arbitration, and then you can ask more specific questions. What do they say about an umbrella clause? What's their view on MFN? This is the process that's going on. It's not about neutrality, if we're honest. It's about getting that vote. So what have we done to our arbitration process? What have we made it into? We have caused it to degenerate. The process now is degenerating into something where, in fact, it's not the ideals. The premium is on how good is your due diligence. That's what's important. And that's unfair, because there's inequality of information around the world. Not everybody can do the same due diligence. So instantly, the process is stacked against various participants. If we continue the scrutiny a bit further and think, what is the essence of the process now? It is as follows. Each side does their best to secure the most robust arbitrator who will fight for them in the deliberation room. Now, can I just ask you to pause for a minute? How different is that from trial by combat? I mean, trial by combat was a very effective form of ADR in the Germanic law. And it had various stages. Trial by combat was where you would fight your opponent. Now, there came an amazingly inspired procedural reformer in Germanic law, and that was Louis the Pious, who was the Lord Wolf of his day. Because his procedural innovation was you don't have to fight yourself now, you can get someone else to fight for you. And that was a major step forward in trial by combat. So you would then choose the best fighter to go into the ring. How different is our system as a matter of analysis? That's what we're doing. We have downgraded our system to a battle of co-arbitrators who can get the best side of the chair. Now let's move to the second one before I get rugby tackled off stage for taking too long. Moral hazard. If party autonomy doesn't demand this particular solution, and it can actually be, if we collectively apply our imagination, it can be satisfied by other techniques. What are the countervailing dangers of not changing? What is the moral hazard? Now, Judith has set the standard a little bit too high. She says we can only look at really actual bias or bias that can be proven. She says we can't talk about just our own experiences. Well, I think that's a little unfair. I think we have to talk about our experiences. We have to talk about word on the street, experiences that we've had from case to case, because we don't have transparency. And you can't set the standard so high as actual bias. You have to look at the field as being more subtle than that. So let me just take everybody in the room for a few minutes to the other side of the arbitration table. What goes on in deliberation rooms? What actually is happening? Here's a little distillation of some experience, mentioning no names for now. If you are a party-appointed co-arbitrator, and I'm telling you this, it feels different to if you are appointed by an institution. Whether you like it or not, it feels different. Why is that? That is because there are extra forces in your head. You are sitting there, and because if you are, not everyone, but if you are human, you will have these emotional responses. They are as follows. You want to be nice to the party who has been nice to you by appointing you. You can't get out of that. They've done something for you. They've appointed you. You're not going to be there and be all sort of hostile and obstreperous. You want to be nice to them. You want to return a favor. There's some element of reciprocation. You want to prove that all the time they spent on due diligence was actually paid off and it was correct and you were a good choice. And you want that all the more so if you have some professional familiarity with them. All the more so if you went through an arbitral interview beforehand and they asked you general questions, not mentioning anything about the case, would you do this or would you do that? Then you've got that link already. You want to secure your track record, you want to secure future appointments. Actually, all the reasons why you have permanently tenured judges. Now, those are necessarily there. They are forces in your head. So the next question is, how well can you resist those forces? So some people can resist them. If you're appointed by an institution, or an appointing authority, or there's some break, some kind of break between the party and you in the appointment mechanism, there is a massive diminution in those forces. Most of those forces disappear. They're just not there. You don't need to be nice to anybody. You need to be nice to the institution or the appointing authority. Otherwise, you can be nasty to people, or you can just do what you want. The pressure is off. And that tells you something very, very important straight away about the dangers of party appointment. And it tells you about the merits of looking, and we're all capable of this, at alternatives. The truth is that those forces that I have described very often take hold. And I'm now going to give you just a few glimpses of what goes on in that deliberation room, which, and this is all completely confidential, you can't mention this outside of this room. There are well-established techniques that go on as follows. Co-arbitrators, first of all, early on in the case, will prove their neutrality credentials with their chair. That's what they do. So early on, they will make a point of disagreeing violently with the party who appointed them on something which doesn't matter. So they will go into the deliberation room and they will say, that was an outrageous argument. I cannot believe they made that argument. They had the courage to make it straight out. I would not extend time by 1 day myself. All right, so they've made their credentials and they show they're neutral, they're not party predisposed. This is all part of a jockeying. It's part of a positioning. The more that one of them does that, the more the other one will do it as well. So the ante will get raised. What happens in practice? Let's not talk about actual bias. Let's just talk about things which a lot of you will recognize. Weighted, loaded questions from one co-arbitrator to the parties. We've all had them. Intervening questions which actually sound a bit too much of a witness, like cross-examination, but all going in one direction. Worse still, the tribunal has a preliminary discussion about what they think the strengths and weaknesses are of the case, and then, going back into the room, one of the arbitrators starts asking questions to fill what is perceived in the tribunal as a gap, or an inconsistency, or a problem. Then there is jockeying that goes on with co-arbitrators to get the attention of the president. I'm loath to use the technical expression, brown-nosing, but it happens. And of course, it's counterbalanced always by the other co-arbitrator. And then you have the danger of dysfunctional deliberations. Because somebody is pushing one side and the other arbitrator is pushing the other side, the deliberation becomes polarized. And that downgrades the quality of the deliberation. And it leads to poor reasoning. In Jan Paulsen, in his words, he says something cobbled together to encompass the result of an unprincipled negotiation. Unexplained or inexplicable diversions or obiter dicta verging on contradiction or incoherence just to show that one arbitrator has done his best. And so in concluding, my message to you is this. This is not a system that we all intended. This is not what it should be. Let's not downgrade it further. We have a collective responsibility not to downgrade it, to make sure it remains legitimate and trustworthy. So how do we do it? We can do it. The answer is not simply you default blindly to what we have always done. The answer is you step up. We all transcend ourselves. We resist the temptation to do what we've always done, and we simply look to the alternatives. And believe me, there are alternatives. And those are workable, and as long as they're workable, the answer is absolutely obvious. You have to support the motion. Thank you.
Well, you know, Toby has given us a lot of ideas about how we can run a future debate and the role of hand-to-hand combat in deciding who should be the victor. It gives me great pleasure now to invite the next speaker, who, as you know, has the singular distinction of being counsel for UCOS in probably the largest arbitration ever. Without further ado, Emmanuel Gaillard.
We were actually going to take a minute or so off Mr. Gaillard's time because Ms. Gill went over her time. But Mr. Landau went over his time even more. So we'll leave things where they stand.
Thank you, thank you.
That's very fair. Thank you, Mr. Chairman. So now that Toby Landau has antagonized 2/3 of the tribunal by challenging me, I can limit my remarks to 3 points. The first is the methodology underpinning the notion. If you want to understand motion, you have to deconstruct it and see of what it's made of, even if it looks good. And let's see if it tastes good. The basic element in the motion, the ingredient, is a number of oral stories in which an arbitrator would leak the award to the party. You have the Lowen case where the arbitrator is naive enough to brag about having been pressured by the US. You have a LCIA case in which the party arbitrator was challenged for having leaked the award also. I had my own case. I was the chairman in a case in which one of the party-appointed arbitrators, we deliberated, we exchanged draft awards. He sent the draft award to one of the parties. And that party was naive enough or inexperienced enough or stupid enough to file that in a court litigation in the US saying we won, it's res judicata. So we had not rendered the award yet. So it was a bit problematic. I rushed the award, and the federal tribunal said that the award is the idea of what we are going to decide, not the actual piece of paper, fortunately. Another case is Pe Casado, which is notorious for many things, including the fact that the party-appointed arbitrator did, by the state, did brush and told the state what the award will be, or the draft award, yet again, will be. And then ICSID was stupid enough to receive them ex parte, because the party, not only they received the award before it was even finalized, but they went to ICSID and said, well, we are losing in this case, it's a disgrace, it's an awful disgrace, so we want something to be done about it. And it was not even an award, so of course the arbitrators were removed. So we have all kinds of horror stories regarding arbitration, but this is only a small, tiny fraction. That may be the most interesting part, but it's the tiny fraction of what's going on in arbitration. It's not good enough for the motion. They make these horror stories, but you have to use a legitimacy sauce to make them stick together. Legitimacy may be the most abused word in international arbitration these days. People know, self-appointed NGOs, professors, sociologists, all kinds of good minds know what's good for arbitration. What's good for arbitration, what's legitimate, it's not what the parties want. It's transparency, it's an appeal, because you want to ensure a hypothetical consistency. You want now to take away from the parties the right to appoint an arbitrator. Let's call it a court. It becomes a court. So you don't need arbitration if you are going to have a court. Of course, what you want to leave to the parties is the privilege to pay the fees, and that's what the EU wants to do to arbitration. It's like a court. You don't even call them arbitrators because it's a dirty word, and the parties can only pay. That's what some want to happen to arbitration. But when you talk to the parties about, well, it's good for the system, you talk about what's good for the system, parties, I'm sorry, I'm maybe too naive, but I thought I was just solving a problem I have with my opponent, and we were in agreement to have a tribunal solve it. I'm sorry, I must be very naive. No, that's not what arbitration is these days. We'll tell you what's good for the system. Now, if you apply the same, and that's my point, if you apply the same recipe, which is, of course, not a good one, to the court system, what does it give you? Do you have horror stories? Yes, plenty of horror stories. I would commend you to read Amnesty International on the independence of the judiciary in the world, and there you will learn lots of horror stories. And let me give you one of my own, since I was reminded of the UCOS case. You know that in one of the ancillary cases of UCOS, there is a dispute on the assets, the former UCOS assets, which are outside of Russia, mainly in the Netherlands. And there is a dispute. Rosneft wants to say it's my assets because Rosneft inherited the UCOS assets through the phony bankruptcy. And in In the Netherlands, there is a dispute on the rest of the assets. The former management has created a trust to say this belong, in fact, to us and to the former shareholders. Now, in that context, litigation happened in Armenia. Why in Armenia? Because some of the assets were owned by an Armenian structure. Now, in this context, it transpired that a judge was asked by his hierarchy, by the authorities, including the Court of Cassation in his system, what to say about that one element of that dispute. In fact, he was given a USB stick with the judgment in it. And in fact, it also transpired that the Rosneft itself, the FSB, and Rosneft lawyers were concocting and strategizing as to how to draft the judgment in the best way in order to be the most convincing for a Dutch court, because the idea was to have a judgment in Armenia and enforce it in the Netherlands where you had the assets afterwards. So talking about horror stories, you have wonderful evidence of markups by the lawyers of the purported judgment, which was handed to the judge to adopt. Now, the judge fled the country. He received political asylum in the US, and he testified about all this. So that's a nice horror story. Let's put a little bit of legitimacy sauce on it. Is it legitimate? No, it's not legitimate at all. What do? Cancel the judicial institution. That's simple enough. Some judges are bad. That's a typical faulty syllogism. Some judges are bad, therefore all judges are bad, therefore you have to cancel the judicial system in every country. Similarly, some arbitrators leak the award. You have some horror stories. Therefore, arbitrators are bad. Let's cancel the party-appointed arbitrator institution. That's a faulty syllogism, as I hope you are now convinced. Now, my second remark has to do with the essence of arbitration. What makes arbitration great, and I didn't say great again, it has always been great. What makes arbitration great is the fact that in arbitration we make all kinds of choices. We choose the institution, we choose the seat, we choose the applicable law, we choose one of the members of the tribunal, we participate in the selection of the chair, we choose at least the profile of the chair. All these choices are essential to arbitration. And by the way, if the institutions have the right in some cases to appoint arbitrators, it's simply a right which was delegated to them by the parties. The arbitrators, the institution have no right of their own. They just have the right which was delegated to them by the parties. So if some institutions want to say by default, like the LCIA, by default, we will appoint everybody unless you say otherwise, that's a choice. Others will say, and do say that, like the SIAC rules or the ICC rules, by default, you appoint one unless we are in multi-party arbitration or in small cases. And anecdotal evidence shows that the parties are very keen to appoint at least one member. And look at even the chair. Even the chair, and one could say that when the chair is to be selected by the co-arbitrators, we all know that this has been perverted. And now you say, yes, but we need to be transparent. So let's talk to the parties. Let's do it in consultation with the parties to be transparent. Now, and what it makes is you can take all the statistics in which the parties chose the chair through the co-arbitrators. In a sense, it's the parties who channel, because they give instructions to the co-arbitrators. They do it transparently, but still they do it. So the parties are very keen to choose at least one arbitrator and the profile of the chair, if not the chair by consent. And in many cases where we had a recent case in which the parties said 3 arbitrators appointed by the in ICC, appointed by the institution. At the end of the day, when the actual trial, the actual case popped up, we decided to appoint all 3 by consent. Now, my last remark has to do with the system, because I know I cannot get away with talking about the system, what's good for the system. So I have a good argument, which has never been used so far, so it's a risky one. But I believe it's right, about the good party-appointed arbitrators do to the system. And I think there is a direct correlation between the sense of ownership the parties can have in the arbitral process, a direct correlation between that sense of ownership and the willingness to satisfy the outcome. When you have an award, in 90% of cases, it's satisfied voluntarily, which is amazing, and that's why the system works, in commercial cases at least. And why is that? Because think about, oh, I don't like the award, it's bad. And you know, who is this arbitrator who slept all along, never asked a single question, didn't open a piece of paper? Who is the idiot who appointed that arbitrator? It's me. So, well, okay, fine. So next time I'll do better. And who is the idiot who appointed that chair who didn't understand the thing and was too idiotic to understand my own fantastic arguments? Well, in fact, go back to the file and we agreed, we had the short list and we agreed. So, yeah, okay, so let's talk to the parties. Let's talk to the client. We'll say, next time we'll do better. And I think that there is a direct, in more general terms, there is a direct relationship between the participation of the parties in shaping the system, in choosing the arbitrator, including the chair, and that's why arbitration works well. And I think the arbitration is facing a big challenge. The big challenge is standardization, and this standardization would be at its paramount if we were to let the institution appoint every arbitrator. That's why we need to protect arbitration. We need to make it great again and to reject the motion. Thank you very much.
Thank you, Emmanuel. And now it's time for you, the floor. We see many eminent faces amongst you. Do you have mics? Roving mics? Yes. So we're going to throw it open. You can say something, you can add a comment, you can air your complaint, you can heckle the debaters, you can ask them questions which they will, if they do not answer, will be taken against them.
Oh, no.
Yes, Albert.
Can I ask a question of the floor motion? We heard very little as to the alternative to the parties appointing the tribunal. I suppose you would argue that the institution should appoint all 3 members of the tribunal, but might that cause other problems such as entrenched cronyism?
Yes. We will leave that for now. We'll leave that for now. Thank you, Albert. Sapna, you want to take it?
Are we answering directly? Why don't we answer that
In the 5 minutes. The debaters will respond in the 5 minutes that they have if they choose to answer it. Yes, Sapna. Okay. Oh, yep, sorry. Yes.
We're being told that the practice should be abolished. If we're not to act in vain, and Toby came very close to addressing this question but didn't quite cross the threshold, who is to do the abolishing? Because you've urged us all to act in the closing remarks that you made, but I'm not sure how we're supposed to act. Is it being said that the New York Convention should get a new clause saying that any award which is rendered by party-appointed experts is not enforceable under the Convention? Or is it that institutions themselves should act singly or collectively to abolish it? Or is it being suggested that we, as advisors to parties, should be encouraging them to be self-effacing and to give up this right? Because ultimately, otherwise, perhaps this motion is simply, should SIAC abolish the right? And then, as Judith has suggested, the matter becomes a competitive one between institutions, and the parties can choose.
Thank you. Well, we would urge some questions to flow this way. Yes,
I like
Sapna.
the question so far.
I have a question for those against the motion.
Great.
They have addressed us very clearly on cases of obvious bias of arbitrators, but they haven't yet addressed in any detail the issue of subconscious bias. And it strikes me that that's really the key to this issue. And it's the point that was raised by Toby Landau about human nature being that you want to reward those who reward you. We did have one response, I think, from Judith, which is that what you will end up with will be a compromised award. But from the citation that Toby gave from Jan Paulsen, there is a suggestion that really what you get is a cobbled together award with very poor reasoning. So could I ask those against the motion to really address head on this issue of unconscious bias, not a really obviously biased arbitrator who'll be marginalised by the rest of the tribunal, but one who isn't obviously biased and probably doesn't know themselves that they're biased.
Yes, I think, yeah. Could you get...
Thank you. Hi, my name is Samuel, and I used to work at the SIAC. And so at the
I know you,
SIAC,
Samuel.
at the SIAC, you have time to dream. And I recall when we were considering...
Excuse
no,
me?
we used to have time to dream. Sorry, not anymore. yeah, I should care. Once in a while, we were considering the new rules.
You no longer need to be afraid.
That's
Samuel.
true. But, yeah. When we were considering perhaps some suggestions for the court in the new rules, one of the suggestions that I remember discussing very vigorously with Kevin Nash was, should we suggest blind nominations, and where a party appoints, but the arbitrator is by no means allowed to be told who appointed him. And I suppose the question for then the Lamilan panel would be, would such a suggestion be workable at any point? Thanks.
Thank you. Yes, right at the back.
Hello, I'm Carrie. I'm from China, Zhongrong Law Firm. So my question goes to Mr. Toby Landau. So my question is whether there is a perfect system that can eliminate all the moral hazard. If not, why the existence of moral hazard can justify abolishment of the current system? Thanks.
Thank you. Yes. Yes, Mike is coming.
Those who were for the motion...
If you could introduce yourself.
Sorry, Rishabh Gupta from
Yes.
India. Those who were for the motion made quite a lot about the practice of issuing dissenting opinions, especially in investment treaty arbitrations, by party-appointed arbitrators. Why should that necessarily lead to abolishment of party-appointed arbitrators? The easier thing, perhaps, would be to just abolish the practice of issuing dissenting opinions, especially given that the Vandenberg article that Mr. Kambata mentioned itself finds that dissenting opinions in investment treaty arbitrations make no contribution to the growth of law because they're never cited, or even on one instance has a dissenting opinion been cited.
Thank you. Again, I will urge if there could be some more questions this way.
So I have a question from my two party-appointed co-arbitrators. It's a question for Mr. Landau.
No, it's going. No, I'm not taking more questions.
The question is, could he be a little more specific? He asked for specificities in his speech about his challenge. Who is being challenged and why?
Yep. Darius will be addressing that.
Mr. Kambata?
Straight away, both Ms. Reed and you, Mr. Bond, for your previous writing and clear predisposition against the motion, bordering on bias, but not actually bias.
Ms. Yi will consider that very carefully and make a decision.
Thank you, Mr. President. Yes, Ms. Reed.
I did not say to Mr. Landau that I was against your position. I said I was against you.
That's all right then.
It was entirely meant ad hominem. Thank you, Ms. Reed, for clarifying
That's
that.
all fine.
Yes, that's all fine. All right, I think we've come to the end of the audience participation. If I can now invite a member of the proposition. Have you all decided?
No.
Yeah, maybe we'll give them a couple of minutes, firstly, to decide who.
Why don't you go first?
Can I go first? Yeah, then you can
give me a couple of minutes.
Sure, you have 5 minutes you can share. You can share it between the two of you. That's fine.
All right. Can
you just time it?
Yeah. I'll do it from here. All right. Thank you very much for all those people who asked a question of the other side. There are a number of points to make. Firstly, this argument gets itself downgraded if we just think about extremes. It's not about horror stories. It's something much more subtle than that, including when we talk about unconscious bias. Secondly, it's not about saying, well, this is syllogistic reasoning. If there's a horror story in the judiciary, we don't talk about abandoning the judiciary. Again, it's a much more subtle point. And it's not about dissenting opinions per se. Dissenting opinions are fine. That's not the problem. The problem is dissenting opinions give you a little window into what the dynamics are. And it's those cases where you don't get a dissent, where you won't see it, but those dynamics may well still be in play. And it's the fact of the way in which dissents go, that they all seem to be in the direction of a party who has appointed the dissenting arbitrator, that again shows you the dynamic. Now, the key point here is the question addressed by Albert, and a lot of people have come back to it. What are the other solutions? There are many other solutions, and we are all able to imagine probably many more than the ones I'm going to outline. It's not just a question of getting an institution to appoint 3 arbitrators or 1 arbitrator, or however many. You can have many different techniques. For example, an institution that will be acting actively in consultation with each party. That can be by way of a list procedure. It can be by way of a backwards and forwards of names. It's just not a direct appointment between party and arbitrator. It's being mediated through an institution. Or it can be done with an appointing authority, not just an institution. You select an appointing authority who does the mediating in between to break that link so that whoever is appointed isn't sitting there thinking they must be grateful to somebody. And in that process, there's any amount of consultation that can happen. And that consultation can take care of these concerns. It takes care of your desire to have somebody of your choice. It also takes care of Emmanuel Gaillard's very valid point that you need to retain ownership of the process in order to assist enforcement. But you can have ownership if you, through party autonomy, have been participating in a process where you have your say. You are having your say. You are vetoing people. You are suggesting names. And lastly, it is not an answer to say, well, the fact that the parties want it means they must have it, because people can be re-educated. And let me give you one example of that. The re-education we have already had for the appointment of female arbitrators because of the pledge. That is something which is already showing concrete results. And it's because we've all got together and agreed we must do it. So why can't we get together and agree? It's not about saying this is now illegal or can't be done. It's about creating a new ethos. And that ethos will be assisted by institutions, by council, in the same way as the pledge. Let's all try and make our process better.
Thank you, Toby. How many minutes does Darius have,
Just
Peter?
a minute. 2, well, great.
All right.
Sorry.
We are not saying throw out the baby with the bathwater. Toby has already outlined some of the many alternatives that are possible. But it will be institution-driven, to answer one of the questions, primarily institution-driven. And institutions ultimately are made up of people like you who will drive the process. Maybe not each and every one, but many will. And many will because of what each of you know in your heart of hearts actually happens in a matter. And Toby gave us a wonderful window into that. It's the lunch talk on who manages to persuade or convince the chairman. It all happens there. And that's not really what we want as lawyers. We want to be able to succeed in that arbitration room on merits rather than on a fortuitous comment made at lunch. Now you can have lists. One of the other solutions could be that the parties suggest the various factors that they perceive to be important in the arbitrator, and based on those, an institution makes up a short list and sends it back to the parties, and then the parties choose from that short list. So we are not saying abolish party autonomy, certainly not. There is a fair amount of party autonomy even in such a process. All we are saying is don't leave it absolutely to the parties to appoint who they choose. That's all. Thank you.
Thank you, thank you. Thank you, Rice. Now, in order to have a semblance of neutrality, I would want to remind the audience that you can jeer and boo as somebody is speaking, and now I leave the floor now to the opposition to address you.
I'll start, we'll share these remarks also. As to the subconscious bias, and it's human nature, but it's human nature on each side, so it's perfectly neutral. Right? And if you think that you have to remove human nature, then you have to remove not only the arbitrator, the judges, but you have to replace all that by artificial intelligence, which is the only way to adjudicate without that kind of this kind of bias. And if you see the cases are pretty, and if you see real life, which some of the critics, not Jan Paulson, but some of the critics of the system, certainly the EU, never seen any deliberation, and they should know that in many cases, it goes very well. Arbitrators do agree, and sometimes it's the co-arbitrators who agree against the chair. And you see the tip of the iceberg is the Tokyo-Stokeles or another recent case in which the chair dissents. So there's a majority of the two-party appointment. Think of the reaction of the party who appointed an arbitrator siding with the other side to make them lose. So that's, it takes guts from, and that's a tribute to neutrality. Now, second point, institutions. The institution should make it happen. Okay, be my guest. And we will see the people will vote with their feet. The parties will vote with their feet. The LCIA has started to say, by default, we choose. Now, unless you agree otherwise, we'll see. If they say, in all cases we'll choose, be my guest. And the third remark, as far as I'm concerned, is politicking. Toby said something which is absolutely self-defeating. He said, yeah, they don't have to be nice. In my system, they don't have to be nice. They're the arbitrators. No one has to be nice to the parties. You can club other parties. They want an extension. They both agree for an extension. I don't care because I'm working on my stats vis-à-vis the ICC. The ICC is putting pressure on me. They want to have fast arbitrations. You agree 4 months, 4 months? No, I'm going to give you 1 each. That's it. I don't have to be nice to the parties, but have to be nice to the institution. So imagine the amount of lunches with the staff members you're going to receive if you are the only one to appoint the arbitrators. The politicking would be extreme and frankly distasteful.
Let me just catch up very quickly on a couple of points. First of all, on party autonomy, I hope everybody in the room noticed the wonderful double act from those for the motion. Darius banged the table and said, we mustn't talk about historical context and party autonomy. And then Toby says, they didn't talk about party autonomy. Well, party autonomy is vital, and what is noticeably lacking, in truth, from submissions for those for the motion is any realistic assessment of the party's wishes. And we can sit in conferences, we can discuss and debate, but at the end of the day, it is the parties who decide whether there will be arbitrations and will decide what dispute resolution they want. 2 other very quick points, just following up from what Emmanuel says. The institutions are not clamouring for this role, and for very good reason. What Toby describes of party involvement by effectively discussing and agreeing and rejecting and toing and froing with the institutions is absolute pie in the sky. What you would get is the institution either being involved in a process which becomes a complete nightmare for it and which it's not equipped to deal with, or you get an institution effectively saying, no, sorry, I'm going to make the appointment. And when it does, you can just hear the complaints. Too many civil lawyers on my tribunal, too many common lawyers, too many people who are past their prime, too many inexperienced people. It's unworkable, I would suggest, as a default approach. And then finally, this point about, are we overstating, talking about obvious bias? Well, look at this motion. We are talking about abolishing what, in truth, we all know is something parties hold very, very dear. The proportionality suggests that there must be something serious. Mere unconscious or anecdotal suggestion of unconscious bias is not appropriate. The arbitrator behaviour we've heard, the sycophancy, the pantomime acting, that does not accord with what most of us know happens in deliberations. And finally, what it always seems to come down to is they do it because they want repeat appointments. Where's the evidence? Where's the evidence of that? Thank you.
Thank you. Thank you.
All right, we withdraw the application.
That is noted.
Well, the moment of truth when you now get to decide the outcome of this debate first. So we're going to have a show of hands. Now we've got about, what, 400 people in the room? Yeah, so it's going to be a little hard, but let's start with, so just raise your hands, one hand, right? Right, just raise your hand. So I'll start with all those in favor of the opposition. Okay, so please raise your hands now. Okay, can somebody take a quick count? Just hold them, please. We do want to count them. Can you count the left side? Adeline, can you count the right side? Bear with us, bear with us.
In order to maintain the very strictest judicial independence, we're not watching.
Okay. Thank you for that. Just keep count to yourself. Don't tell us yet. I think yeah, we're all done. Thank you. Okay, now all those in favor of the proposition, please raise your hands. Okay, just hold them there, please.
There's more hands up at the back for us.
Yeah, the right side we're done. Just the left side. Left side.
Okay, no, keep your hands up.
Yeah.
Both of them.
Okay, can you all tally and let me know what the audience vote is? That seemed a little close from over here. We may have to settle this with a duel. But we still have to hear from the judges, though.
I'll find.
Yeah, I'm going to ask the judges in a moment whether they need time to deliberate. Yes. It is rather close.
They shouldn't hear. They shouldn't hear. I want due process here. So.
Well, no. Let's talk about it. We obviously there is a point of objection now. So the point being said to me is that the judges should not hear this verdict. Okay, let me put it to the vote to the floor.
No, this is not a democracy. This is an adjudicative process. We are the tribunal, and I am the chairman. I decide procedural issues. I think it's quite right. I think we should...
Okay, to be quite fair, it was decided before the debate that the judges, having heard the vote of the audience, would then decide their vote.
Oh, I see.
All right, so it's two separate forum. And so for the votes for the opposition, because that was the order, 118 hands in support of the opposition, and for the proposition, 103 hands. All right, so as far as the audience are concerned today, by a narrow margin, there is a request for a recount, which is being declined now. Now, do the judges need time to? No.
The tribunal has carefully deliberated, and we're going to deliver our opinions seriatim, very, very briefly, mindful of the time.
Well, I am, despite my saying I would be against Mr. Landau, I am in favor of the motion, slightly restated that it need not be abolished, but it should be improved. And it's not, as someone pointed out, it's not to me a question of whether we allow parties to be arbitrary in their appointment versus institutions being arbitrary in their appointment, but there being a list process and more of a back and forth with institutions who can provide equal documentation on arbitrators to the parties as they proceed. And I'll point out also that until just now, until the questions, nobody addressed this well-documented fact that parties rarely make diverse choices in international arbitration. Institutions do, and that's one of the only ways to make sure we get broader representation of all sorts of ideas and other issues on a panel.
Thank you. Ms. Yi?
I have two practical points regarding, actually on this side, because if we're talking about the companies from developing countries, they are the newcomers to the international area, and therefore, if we, I mean, in our practice, we always said that if we lose a case, we always blame arbitrator. So it doesn't matter whether the arbitrator is appointed by parties or whether the arbitrator appointed by institution. And if we now argue that the arbitrator should be all appointed by institution, that makes the life of our counsel easier, because then we just simply blame the institution. So that would be one point. And the second point is in terms of why it's important for party to having somebody who known to them as appointed as arbitrator, is because when they come to something new to them, when they see some face at the at the bench, and who happen to be know their culture, particularly know their language, and I think that gave them a great comfort, and that's the reason I was on this side.
Thank you, Mr. President.
Well, there's a famous saying by Lord Denning, who delivered judgment in the English Court of Appeal in a case. He delivered judgment in a three-person tribunal, and when he had finished delivering his judgment, he went behind the curtain with his two judicial colleagues. One of them, rather timidly, expressed the view that he didn't agree with Lord Denning's conclusions, his holding in the case, which prompted the second of the three judges to say that he too disagreed with what Lord Denning had delivered as judgment from the bench. To which Lord Denning imperiously remarked, well, then the two of you will just have to dissent. I had rather hoped that my two co-arbitrators would agree so that I could use that line. But since they didn't agree, I used it anyway. Apologies for that. And I've been using the last 3 minutes to try to figure out what I would say as a majority view. I actually think there's force to both sides of the proposition. There no doubt is moral hazard to appointing party arbitrators. On the other hand, does that really mean we should abolish something that has worked so well, especially here at SIAC for the last 25 years? There's an ancient adage, we're not supposed to look at history, but an ancient adage that if it ain't broke, don't fix it. And I suspect that is an adage that we should all pay attention to in the future. Thank you. I'm not sure where that leaves the tribunal. Perhaps we can have another debate next year to decide that question.
Exactly.
I did vote. I voted for the first half in favor and the second half against.
I'm afraid we have a hung judging panel.
I think you did too.
And that too may have to be settled by something along the lines of a fist fight. But guys and girls, thank you for coming. You've really made this evening special. So many of you have appeared. I think next year we need an even bigger venue, especially if we're going to have a boxing ring in the middle. But thank you. But please do stay on. You know, it leaves. I think on behalf of the audience, we'd like to thank once again the effort, the great efforts put in by the speakers, the debaters on both sides. Do stay on for the drinks and the fellowship. Thank you. Thank you very much.